Thanks for having me down. Appreciate it. So this is the Economics Club for the most part.
Yeah.
All right, that's good. If I could go back to college, I would have studied economics. I think it's one of the best things you can study as an undergrad. It teaches you to think a certain way, which is beneficial. So I went to Boston College as well, which is Jesuit school, which is Jesuit high school. So we have that connection as well. So appreciate you having me. So I'm a litigator at the Goldwater Institute, and what that is, it's named after Barry Goldwater, 1964 presidential candidate, former U.S. senator, and we have basically two teams. We have a policy team where we craft model legislation, and then we get it passed in state legislatures throughout the country. And then we have a litigation team where we use mostly state constitutions. So when you think about like constitutional law, a lot of people just think of the federal constitution. But there's actually 51 constitutions in the country. And the federal constitution is just a floor for protecting our liberties, including our economic liberties. State constitutions can go further in protecting individual rights. So our philosophy at Goldwater is we use state constitutions to advance and protect liberty, and we're a limited government, free market organization. So what I think is interesting for your guys' perspective is how you can use the law, how you can use a team of litigators at an organization like Goldwater to drive public policy. So we work in tandem. When we advance a bill in the legislature, oftentimes we've got a case going in the courts at the same time. So I want to talk a little bit about that and how that works and how those things are related. But I want to start with, I think, just some conceptual things. And actually I want to start with a controversy. You guys ever heard the term judicial activism? What does it mean to you guys? What does that mean when you hear it? Let me actually ask this. Does it have a good connotation when you hear judicial activism? It's usually a pejorative, right? So what does it mean? Give me a definition of judicial activism.
Is it like using the justice system to project forward to certain agenda or policy?
Sure. Yeah, exactly right. So when people I think use say judicial activism, it's maybe judges advancing whatever they think is their policy preference in a way that's not appropriate for a judge to do. And oftentimes it's used as a pejorative, and both on the right and the left. We're in a presidential election. You're going to hear both candidates. This might be one issue where they agree that judicial activism is a bad thing. Oftentimes, though, when people use that phrase, judicial activism, what they really mean is judges doing things that they don't agree with. That's really how they define it. So that would be, for example, conservatives disliking liberal judicial activism, or liberals disliking conservative judicial activism, rather than the act itself. So I think it's more important to ask, what's the proper role of courts in our republic, and how should they or should they not influence policy? So we all learned in high school civics that the judiciary is a separate but equal branch of government, right? Separate but equal. So what does that mean? If anything, I think our founders understood the corrupting nature of power. And they knew, and Madison said this in Federalist 51, that ambition needed to be checked with ambition. And they knew in a republic, both the legislative branches and the executive branches are going to expand their power. They're always going to push to get more power. So there has to be a check on that. And the judiciary is that check. So I would submit to you that when the judiciary has been least active, when courts have been more willing to defer to the legislature, to the executive, that's when we've seen some of our worst historical moments. That's when we've seen some of the worst court decisions. Plessy v. Ferguson upheld separate but equal doctrine. That's when the court refused to act, refused to enforce the Constitution when the court should have. Korematsu, that was the Japanese internment. That was when the court refused to act, refused to enforce constitutional provisions. We've also seen the largest growth of government, particularly the federal government, when courts have refused to act. And the reason that's the case, it really comes down to two words, and that's the Commerce Clause. If you ever have your handy Constitution, you open it up to Article 1, Section 8. It enumerates some very specific and limited powers of Congress. They include to coin money, to operate a post office or post rails, to engage in tribal affairs, to maintain a navy, etc. But they're very limited. So the scope of the federal government's power is very limited in our Constitution. And then there's a provision in there to allow the federal government to regulate commerce among the states. And the courts, over time, have viewed that small provision for allowing the regulation of commerce, as economists understand, to basically say anything goes. The federal government can basically do most of what it does under the commerce power. There was a case a long time ago in the 30s where there was a family farmer, and he was growing wheat on his own family farm. Never introduced it into interstate commerce. Never even sold it. He was just going to eat it with his family. And the Supreme Court said no, and Congress wanted to regulate that. They wanted to set the prices of wheat. And the Supreme Court said, yeah, that's okay, because even if it's only going to be consumed by his family, that will still, down the line, somewhere very far down the line, impact the price of wheat. Therefore, it impacts interstate commerce. Therefore, Congress, you can pass legislation in this area. So the reason I say all that is because activism, although people understand it as a pejorative, really shouldn't be. Judicial activism where judges are making up law is bad, but judicial engagement, where they're enforcing the contours of our Constitution, is not only desirable, but it's necessary in our republic. I mean, where else is the small guy going to go to get relief? Is it, somebody can go hire a team of lobbyists to try and get some laws passed? Or can all of us go to court and have our fair day? Particularly if the government is the offender. Particularly if there's a law or regulation that's impacting your right to get a job license or your right to start a business, you can go to court and seek relief there. So I would say that rather than judicial activism, we should think about judicial engagement, and we should think about it as a good thing. So, so at Goldwater, we come to our work with that in mind, with how can the courts be used to protect and advance liberty? And there's two ways in our state constitution, or there's two ways that we do it. So one, state constitutions, they have provisions that federal constitutions don't. And often they have provisions that impact things like economic liberty, which we'll talk about a couple of these cases. And then they have similar provisions as our federal constitution, like right to free speech. But state courts can interpret that broader. So there's two ways in which public interest litigation can advance liberty interests, free market interests. So there's a case we litigated under what's called the gift clause. 47 state constitutions have a gift clause. And here's what Arizona's says. Neither the state nor any county, city, town, municipality, or other subdivision of the state shall ever give or loan its credit in aid of or make any donation or grant by subsidy or otherwise to any individual, association, or corporation. So what does that mean? The government can't give money, can't give taxpayer dollars to private companies, to individuals, unless there's some public benefit. Okay, so if not only does there have to be a public benefit, but the value that the government receives in return for the expenditure has to be fair. It has to be what's called roughly proportional. And we see governments giving subsidies to private enterprise all the time at the federal and state level, right? You have Solyndra was a big controversy a number of years ago. The federal government subsidized a company to the tune of tens of millions. Actually, I believe it was hundreds of millions. You guys remember that? Yeah. Solar power. Solyndra ended up going bankrupt, and all these investors, including taxpayers, ended up losing all of this money because the government had chose a winner or a loser in the marketplace. So unfortunately, the federal constitution has no gift clause provision. There's no way for us, for taxpayers, to go to federal court and say, hey, feds, we don't think you should be giving money to a private solar company because we don't know if it's going to be successful or not. You know, gambling with our taxpayer dollars. But in state courts, we do. We have these gift clauses, and they exist in 47 state constitutions, including Arizona's. So back in 2007, this was pre-recession. So this is when times were good. There was a lot of money to go around. The city of Phoenix, like a lot of major cities, was looking for economic development projects. Okay, they were looking to see where can we invest taxpayer dollars, to try and promote commerce in the city. And they found a private developer in a development called City North, which was like a mixed-use project. So that included businesses, some condos, that sort of thing. And it was basically this Taj Mahal of shopping malls with some condos above it. And the city of Phoenix structured a deal this way. It said, in exchange for $97.4 million, we're going to give this to you, City North, private developer. This is all public money going to private hands. We're going to give this to you to use with it as you please to develop this new development. In return, we're going to get 200 parking spaces for exclusive use of city residents. So, of course, in the minds of all of these city council people, they're like, we want this new development. It's going to bring jobs. It's going to bring tax revenues. So we think it's worth giving $100 million, basically for nothing, for 200 parking spots. If you do the math, that's $5,000 per parking spot. So we looked at this. The Goldwater Institute looked at this, and we're like, you know what? That looks a lot like a gift. That looks a lot like the government giving public tax dollars to private industry without corresponding benefit. And we don't think that that City of Phoenix should be allowed to do that. So we sued on behalf of taxpayers. And the case ended up going to the Arizona Supreme Court, and the court there held a couple things. One, government, you can't do that. You can't spend money on purely private projects unless there's a public purpose. And two, if you do it, you got to get more than 200 parking spots for $100 million. There has to be roughly proportional value. So the court ended up holding that, but applying it proactively. So it didn't apply to the City North deal. Interestingly, by the time this got all the way up to the Arizona Supreme Court, the market had gone to hell, and the City North project was dead. The money, fortunately, was tied up. It was never given to City North while litigation was ongoing, but had it been, it would have been lost entirely because the project was a failure and all of those tax dollars would have been lost. But we walked away from that, and $100 million was saved, and we now have this opinion in Arizona where we can use this gift clause, both in Arizona and in the 47 other states that have them as we do litigation outside of Arizona, to prevent these sorts of public expenditures where there's not corresponding public benefit. So I'll give you a couple more cases that we litigated under that provision, because I think it's maybe helpful to think about all the different applications you can use and just building out this one provision. Any questions as we go on? Feel free, by the way, as you have questions. Yeah.
One point and one question. Do you all just litigate in Arizona, or do you litigate nationally?
So we litigate nationwide, although that's a new endeavor for us. Starting about 2 years ago, we started taking cases outside of Arizona. We have about 8 active cases outside of Arizona. In fact, our first one was here in Louisiana in a federal court where the Department of Justice tried to enjoin or stop Louisiana's school choice program, and we ended up intervening on behalf of families and arguing that the judge in that case didn't have authority to do what he did. He used a 40-year-old desegregation order to strike down a program that was active in 2012, which desegregation had nothing to do with it. So, so yeah, to answer your question, we do it everywhere, and the model now is to take some of these cases, like these gift clause cases where we've had some success in Arizona or elsewhere, and then replicate them where those claims exist in other states. Yeah.
Have you looked into taking these gift clauses and how they might apply to public financing of sports stadiums?
Oh, yeah.
New sports stadiums?
Yeah, funny you mentioned that. The most controversial issue we ever got involved in involved the city of Glendale subsidizing to the tune of $15 million a year over a very extended period of time the Phoenix Coyotes hockey team. Hockey in the middle of the desert, free market might not support that, but the city of Glendale was willing to support it with taxpayer dollars, and so we ended up getting involved in a very major way with that deal. It wasn't exclusively stadium financing, but it was subsidies to the private team, and they ended up totally restructuring the deal, and what they originally wanted to do, they couldn't do because of the gift clause. But it's funny you mentioned that issue. Stay tuned, because that issue might resurrect itself in Arizona.
I know in Georgia, where I'm from, the Falcons and the Braves are getting new stadiums, and there was a whole controversy whether the tax money should go to the companies that build those new stadiums.
Yeah, exactly. And those are the types of projects where, I mean, arguably there's a public purpose for that, right? Arguably, it's community, whatever. But, you know, is the public really going to get back what it pays for the expenditure? I mean, is it not the private company or the NHL or whoever that's going to be the primary beneficiary? Yeah.
Yeah, I was just gonna ask, so is the issue the fact that government is giving public money for whatever investment purposes, or is it the issue how the money is spent? Let's say if you're giving that a gift or a tax subsidy for building a hospital or for research into cancer versus putting it for building a stadium which may not save lives. So I'm trying to understand that the issue, just giving money or actually how it is spent.
Yeah, no, great question. Both is the answer. So when courts look at these deals, the first question they ask is, does this serve a public purpose? So a county hospital clearly serves a public purpose, right, for indigent people that can't get medical care. So there's a public purpose. But then the court asks the second question, is what the government is spending, if it's spending $100 million, is it getting roughly $100 million back? And that's where a lot of these private industry stadium deals, that's where they're going to fail, because really the public's not getting anything back from those. But for a hospital, it probably will, because it's purchasing beds, it's getting beds back, et cetera, et cetera. Does
So
that
in
make
some
sense?
cases, the government can give subsidies if they're going to for budget.
Right, and if they're getting the value of the expenditure back. So they can't just give a pure $200 million to build a stadium if they're not, because the stadium is not being built for the public, that's being built for the owner of the stadium, right? Whereas a public hospital arguably is being built for the public. So are they getting the value back in exchange for the expenditure? Does that make sense?
Can you say in your organization's mission statement, if so, how is it specifically
How's it look?
specifically performed?
For our mission statement. So our mission is to advance and protect liberty in, in the 50 states, using limited government, pro-free market ideas. And so we perform in state legislatures by drafting model legislation and getting it passed, and then litigating cases that allow for individual rights to be vindicated in court. So we have a pretty good track record. We have in our litigation team, of all the cases we filed, and we stood up in 2007. We've done 50 cases since then, and we have a 72% success rate, which is pretty good for a public interest firm. Even the big ones like the ACLU, Institute for Justice, those are other public interest type firms. Public interest litigation is always an uphill battle, so we're proud of that.
Where do you get your funding, and also what do you do in the case of the money's involved? Y'all get a percentage of the winnings, or how does that work?
Yeah, great question. So where do we get our funding? 2/3 of our funding comes from private donors. We don't accept any more than 5% of our budget from any one donor, so we can maintain our independence. Yep. And 1/3 comes from private foundations, so grant-making foundations like Freedom Foundation or something like that. With respect to attorney's fees, all of our cases we take pro bono, so we don't charge our clients anything. But we do keep track of our hours, and some cases allow you to seek attorney's fees if you win, if you're successful. So usually we sue the government, and if we're successful, we'll get attorney's fees, and we keep those and put those back into our litigation work. Yeah, good question. Talked about a couple more of our cases that I think are pretty fun, and there are ways that we've used, and I use these cases because they're ways that we've used this gift clause in a way that you might not think. So it's a way public interest litigation can be used to impact other policies that might not be directly on point. Anybody ever heard of release time or official time? Probably not. Okay, so imagine this. Imagine you're a local city council and you decide to give 10 of your employees to McDonald's. Actually, let's use a different example. Let's use Walmart, everybody's favorite villain. City council decides to give 10 of its employees to Walmart. Okay, they're city employees, but they go to Walmart, they wear Walmart uniforms, they operate under Walmart's authority, they report to Walmart decision makers, they never come to the city, never perform any more city work. Okay, that would be outrageous, right? If these employees were being paid with city salaries, they're receiving city pensions, but they're going to work from Walmart, I think that the public outcry or something like that would be, WTF. Okay, that's happening. That's happening at the federal, the state, and the local level, but it's not, they're not going to private businesses, they're going to private government unions. So, in practices called official time or release time, public employers are releasing employees that were hired to do a government job to go and work exclusively for private unions. Report to the union, do union business, et cetera, et cetera. So, I'll talk a little bit more about the numbers and the costs, but we observed that this was going on in Arizona. And in particular, in the city of Phoenix, the police department had 6 full-time release time officers. So these guys were hired to be cops, but they didn't do any law enforcement activities. They went and did union business, including lobbying, including recruiting members, filing grievances against the city, representing union members in grievance proceedings. 6 full-time officers were receiving city salaries, city pensions, then they also had a bank of hours, and then they also had certain officers that were allowed to go at different times to be released to go and do union activities. The cost in Phoenix was $3.7 million. The federal government also has official time. The most recent year for which numbers are available is FY11. Sometimes the feds lag behind in their reporting. But in an FY11, official time cost federal taxpayers $150 million. The VA is the worst offender. They spend $47 million a year on official time. So think about that. Doctors are hired to care for our veterans. Nurses are hired to care for our veterans, but they're not doing any medical care whatsoever. They're being released from those jobs to go and work for federal unions. In fact, in Phoenix, there was this big VA scandal where veterans were waiting for care and dying because they were waiting for care. We looked at Phoenix numbers, and there was 3 full-time release employees in Phoenix, including a doctor and a nurse, that were not being doctors or nurses, but were doing exclusive union work. So when we saw that in Phoenix, we're like, that also looks like a gift, right? Because these unions are private organizations, and the taxpayer really shouldn't be subsidizing their activities unless the taxpayer is going to get something in return for it under the gift clause. So we sued, and we sued the city of Phoenix and specifically the police union that I talked about. Early on in the case, we got what's called an injunction, where the court said, yeah, we agree, this looks like a gift clause problem. Arguably, there's not even a public purpose for this, because these guys are doing purely private activities, and even if there's a public purpose, city of Phoenix taxpayers, you're not getting your value back. So the city, or the court, enjoined or stopped the practice, and those 6 release time officers had been away from the jobs for which they were hired for so long, and doing exclusively union work for so long, in some cases 15 years or more, they forgot how to perform basic law enforcement functions. So when the court ordered them back to do the jobs for which they were hired, they also had to go back to the police academy for a 2-week remedial training course. So what had happened with that, we ended up, that case is actually still on petition to the Arizona Supreme Court. We won in the Court of Appeals and eliminated release time throughout the state, but we'll see if the Supreme Court grants review. And because that exists in so many different areas, feds, state, local, we think it's an area where you could use something like the gift clause and try and get change. Now, this is, I'll kind of segue into like public choice issues. At the same time that we were litigating the release time case, we drafted model legislation for the state of Arizona to try and get passed through the legislature that would prohibit release time specifically by law. And that was a really, really tough lift, because the minute we went down to the legislature, and Arizona's legislature it's a Republican majority legislature, so it tends to be more conservative, and the minute we went down there, obviously the unions hated it, because they're getting free workers, they're getting free money. So when we went down to try and get this passed, all of the police unions came out. And then it became, oh, you guys just don't like law enforcement, yada, yada, yada. And a lot of lawmakers were, hey, I love police and fire. Who doesn't love police and fire, So it made it a much tougher political issue, because a lot of legislators weren't willing to vote against those powerful unions that represented powerful interests. So that's why using the courts in a case like this was necessary, frankly. So any questions about that case? I talk about a couple more, and then I want to open it up to any of your questions. This is both a gift clause case, and then we also use some state laws. Anybody ever heard of pension spiking? Okay, yeah. You want to take a crack
Well,
at
I
this?
mean, New York was famous for that in the '70s. They had policemen in the '70s retiring down into Miami area on annual pensions of $90,000 a year because their pension was based, I think, on the number, on their salary, what they earned in their last year. So in the last year, they had guys who would normally work, say, 40 hours a week, anytime in their precinct or whatever. Overtime came up, they got first crack at it, and they had guys working 96 hours a week every week for the whole time, so that and they were getting paid, obviously, overtime for those extra hours, so their earnings in their last year were just so far above what their normal earnings was impossible, unbelievable. And then they said, well, okay, your pension is a certain percentage of what you earned in your last year. It was unbelievable. And that was part of the cause of the bankruptcy problem in New York City in, what was it, 1975, I guess it was?
Sure.
When they had to bring, what's his name, I forget the guy's name, in to try and straighten the place out.
Yeah.
So, yeah, I mean, that was a terrible problem, but I assume it still goes on.
Yep, and that's exactly what the problem is. Your pension is usually based on your last year of employment or your last 2 or 3 years. So people will do things like work overtime in those last few years to jack up the base rate for their pension. And they'll use things like vacation leave, sick leave, uniform allowances, cell phone allowances, missed meals allowances. When we looked at this in the city of Phoenix, it's not funny, it's like taxpayer abuse, but it was pretty funny. There were 64 different types of pay that City of Phoenix employees were using to cash in their final years of employment in order to artificially inflate their salary, including a missed meal allowance. I don't even know what that is. You miss a meal, I guess you get an allowance. And not only that, but you get to count it towards your retirement base pay. So we saw that this was going on in Phoenix. It's, as you say, it's been happening for decades. It happens all over the country. Couple crazy, egregious examples. The city manager in Phoenix. So in the city of Phoenix, we have what's called a city manager. A lot of cities have mayors, and the mayor is the chief executive, and they run like police and fire and all that. In Phoenix, we have a mayor, but he's more of just like a figurehead, and then we have a city manager who actually does the day-to-day operations of the city, like all the police chief and the fire chief and public works folks. They all report to the city manager. So a guy named David Cavazos was the city manager of Phoenix. He worked for the city of Phoenix for 26 years. He actually started as an intern, so he was probably making $20,000 a year when he started. He ended up retiring as the city manager, where his base salary was $240,000. So normally his pension was based on that $240,000. Now we could have a debate as to whether even that's fair. I mean, it shouldn't really be an average of all 26 years, but whatever. So base salary, $240,000. Mr. Cavazos cashed in the following items during his last few years of employment. A $1,200 cell phone allowance, that's not bad. It's nice he gets a cell phone allowance, but that's not bad. A $21,000 car allowance, the city pays for his car, he cashed that in to inflate his pension. $42,000 in unused vacation leave. He had saved up a lot of vacation leave apparently over these 26 years. And wait for it, $200,000 in unused sick leave. So city employees could accrue sick leave without limitation in the city of Phoenix. So he inflated his baseline pension by $300,000 by cashing in all of these benefits that were never intended to be retirement enhancers. And to add insult to injury, Mr. Cavazos retired, inflated his pension by that astronomical figure, and then moved out to I think Anaheim, California, to a smaller city in California, where he got a job as a city manager in that city, where he made $500,000 in pay and benefits combined. But that's a detour there. So we looked at that, and there was fortunately state law that prevented a lot of this. So our case was based on the state law. But when we looked at that, that also looks a lot like a gift clause issue, right? That's a private beneficiary. That's one individual who's receiving that public money. And there's obviously a public purpose for pensions, for paying your employees well. But is the public really getting its value back? So take, for example, one sick day. Say you're Mr. Cavazos is making $200,000 a year. I don't know what that costs. Maybe $200 or $300 a day for one sick day if he's sick and he stays home from work. So that's what the public should expect to get in return. You know, healthy employees, roughly $200 to $300 a day. But if somebody uses that same sick day to artificially inflate their pension, and then they receive, so let's say 50%, he receives 75%, but let's say receive 50% of his pensionable pay, he's going to make that sick day up after 2 years of retirement, right? And he retired when he was 56. So he's going to have a retirement for 30, 35 years. That he makes it up in 2 years. That starts looking like the public's not getting its value out of that one sick day. That's an area where gift clause challenges where you might not think about, pension reform. You might not think about that. Yeah.
I think it's a little worse than you stated. If you think that the average work year is roughly 250 days a year, and it's $250,000 salary, that's $1,000 a day, isn't it?
There you go. Yeah, see, that's why we need economists. That's why lawyers need economists.
I mean, I don't know. I may have gotten math wrong in my head, but I think that's correct.
Yeah, no, that sounds exactly right to me, but I'm not good at math. That's why I'm getting a lawyer. But actually, that's where these sorts of synergies, having public policy, having economists working these issues together is so helpful. To produce. Because for this case, if we ever bring one, if we bring a gift clause case against this, and we might, we're going to need that sort of academic research. We're going to need the actuarial analysis and all that kind of stuff to support our claims that the pay is actually disproportionate. So that you raised a really, really great point.
The example of the sports stadiums, looking at the disproportionality between the cost to the taxpayer versus the benefits to the taxpayer. I think it's become kind of common practice when a group is lobbying for public funds that they would do an inflated kind of economic impact study, right? If their economic multiplier is high enough, they can justify pretty much anything.
Yeah.
Doesn't that kind of, it's bunk science, but doesn't that give them a get out of jail free card?
So I should have mentioned that when I talked about that first case where they subsidized the luxury shopping mall. What the court said in that case, the Arizona Supreme Court, which was phenomenal, is that indirect benefits do not count as consideration. So job creation, tax revenue, that doesn't count.
Okay.
You got to set all that to the side. Well, what's the public actually getting back?
Direct benefits.
Direct benefits.
Okay.
So that's phenomenal. But yeah, in a lot of the states, so 47 states have these gift clauses. Maybe about a dozen are as robust as Arizona's. So in a lot of the other states, they'll do that. They'll be like, oh, yeah, of course there's consideration. It created, 1,000 jobs. It gave us this much tax revenue, or we anticipate it to give us this much tax revenue.
Well, on that point, because I know Anton